Look at dog! I missed her! Good to see you. Absolutely. Since 6:10 this morning.
Nice to see you. Sorry it's under these circumstances.
Up there. Mr. Reed and Mrs. Reed.
Love them.
It feels like we haven't seen them in a lifetime.
Come on in, guys.
Heads up, guys. Hit it up.
Okay.
We love you, Karen.
Oh, Karen, Alan Jackson, little Yannetti.
Woo!
Love Rita. Love Dina. Love Rita. Dina's hilarious.
How was that? You got. Hey, how are you? Good. Good. All right, let me.
Hey, how you doing?
All right, guys, guess what they want? Good morning, everybody. Everybody that's following Karen Reed. In my opinion, there is no way this is being granted based on precedent in this case. The prosecution wants Karen Reed's dad's cell phone information, his records. Same thing that Karen Reed tried to go and get with all of, the clan when she wanted to get the Alberts and all, Higgins and everybody's cell phone records. And then they just, destroyed their phones and shit. So I hope that Bill Reed went and destroyed his phone. That's all I got to say about that. I hope that Bill Reed went and destroyed his phone. Oh, didn't know you guys wanted that. Sorry. There was no, preservation. So I hope that Bill Reed went and threw that fucker in the water. Go fishing, motherfuckers. You guys want to fish? Go fish. But yeah. Absolutely ridiculous. But they want Karen Reed's dad's historical phone. You guys are going to hear all about today. But you guys denied Karen Reed all of those avenues back in the day. So to grant this would be, I mean, come on. So anyways, good morning, everybody. As everybody knows, I've been in Delphi covering that case. Or if you don't know, then hey, now you know. So switching up gears here. There's been a lot of things transpiring here in the Karen Reed case. A lot has stemmed from Turtle Boy and things that have gone on in his case, and with his lawyers asking for certain things. So the discovery process with the Turtle Boy's case has been able to, Karen Reed's defense has been able to kind of piggyback off of that. So I think it's rather just sweet the way that it's just been serving up karma. That, we're just over here blowing our legs off, I mean, it's just all so bad. It's just bad. I mean, it looks so horrible for the Massachusetts police, for everybody that's involved with the prosecution, the DA's office. I mean, it just is bad. It's bad. So Turtle Boy added Mark Betterow to the lineup of his defense team, and Betterow, they've been putting out these letters. Okay, these letters have been pretty just awesome. Everything like someone like me wants to read in the morning. Like I'm like, oh my God, give me that tea. So I've been following it, even though I haven't been able to do as many updates and stuff like that. So today hopefully is that day where we get to talk a little bit about what's been going on. If you guys remember, they tried to say that Turtle Boy and Karen Reed were conspiring to commit witness intimidation. You guys remember that? Yeah, they're talking about that as well. Lana, in early November, aren't they arguing over Karen Reed team seeks DA's personal emails, says prosecution expert, misunderstood data, and prosecutors push to get Karen Reed interviews ahead of retrial, as well as they are going for Karen Reed's dad's phone. So they also, I don't know if everybody knows this, but the trial was supposed to be here in January of 2025. Both sides put in a joint motion that we're going to have this trial in April. Okay. It's too soon because of all the, they brought in this new prosecutor. So they put a joint motion in to say that we want to have this in April. I'm loving it only because the January date was literally the same time as the Drake Moore case for that civil trial. Okay. So when I got the news that they were going to be pushing it back, I was like, oh, I had a personal interest in that. Because I was going to be doing both at the same time. I don't have to do that now. So it's nice. Plus Dr. Moore, I think he deserves his own platform. What is up, Rick? Come on in, buddy. Rick says, you'll have to catch me up on this case sometime, Lana. I haven't followed. This case is one to follow because with the whole everything that's going on with Delphi, this case has a lot of similarities in terms of railroading and just nice little frame jobs. What's the difference, though, is I would love to see, the support that Karen Reed's getting. I think if Richard Allen was a female, this is what would have been happening, though, with people being out there with their signs. But I will tell you this, being in Delphi, it was 4-1, okay, for every 4, because we were supporting not just Richard Allen, just like we're not just supporting Karen Reed, but we're also supporting ourselves. We need to support our rights, you guys, okay? These officers in this area with Karen Reed, I mean, they knew exactly, these families knew exactly what they were doing. Okay. They had a plan. This was premeditated after the fact of when John O'Keefe was put on that lawn. And like, they were going to pass the buck. And they had the means and resources to do that. Karen Reed couldn't frame anybody, you know what I mean? She didn't have the means and the resources to do it. So kind of similar to Delphi, losing evidence, losing, months worth of interviews. Are you kidding me? So, but let's listen. And this is, so when we went down there, up there rather, Bella and I were there for at least a week.
This morning, the cold.
We're going to go in March for St. Patty's Day to kick it off. Because since the trial's not till April, but my birthday's in March. My birthday's March 19th. So yeah, I'm a Pisces. So I'm going to take my happy ass to motherfucking Boston for my birthday and do a TNT, getting ready for the trial. Tailgating for the truth. People in Delphi wanted me to have like a grill out, and I think this is more the venue for me to do that. So I think we will see our first TNT official like grill where I want to cook cheeseburgers, or at least I want to hire somebody to stand next to me while I just flip a few every now and again, So, but I think this is more, that pace for us to do that. But yeah, April. So let's go take a look. We can all celebrate together. Absolutely. Come on out. I'm going to put this on.
You got my address, right?
I got the address. Yeah.
So we had the one local that testified for the defense. We have our lucky shirts. Thank you, Rita. When we were there was a woman making these shirts, and I was just like, here, I wanted to give them some money, just, to cover it, but they weren't like selling them or anything. But I was just like, here, we really want those lucky shirts. They're green. I love green, love orange. And so we got those. Love these ladies. Love this town. I can't say enough, amazing things. I mean, all the credit needs to go to Turtle Boy for putting this case on the map. But everything that he's endured to put it on the map. I mean, this man was arrested. He was charged with 19 felonies. I mean, give me a fucking break. Okay. Like, that's insanity. I can say I know what it feels like to be him. Not on the level that I've ever been. I've been wrong. There he is, wrongfully accused, and people try to get charges on me, but nothing to the extent of this. But I can just say I know what it's like to be doing like your work and people try to fuck with you. So this is Turtle Boy here on the right. We actually donated yesterday to his defense. If anybody in chat, one of the mods wants to put his link up, even if it's just like a couple bucks, you'd be amazed at how that can help. You can also donate to Karen Reed's Legal Defense Fund. This has cost her, you guys, $5 million. Who can afford that? Nobody can afford that. Oh, I slept great last night.
I don't think that will ever happen. There's no evidence.
She's guilty. Fuck, I love it. Who? Your mom? Your mom's a guilty one probably in here. Thank you so much, Susan.
It's a silly question.
So you don't know. If you don't know, it's what's important.
Okay, so here's a recap really quick if you guys don't know this case. Karen Reed dated a Boston police officer. They had been dating for 2 years, and then they go out one night when there was going to be a blizzard, and everybody knew there was a blizzard. And a little town of Canton's kind of like Delphi, but it's like way more like prestigious, like money, hoity-toity type of shit. They were hanging out with, so he's a Boston police officer. They were hanging out with other ATF agent, Boston officer, and they were supposed to go back to the one Boston police officer's house for a quote unquote after party. Okay. I think the best way to hear the quick rundown of the story is I'm going to bring this up just in case people don't know. So I'm going to do it like this here. I'm going to play this while I pull this up because I do have some new viewers. So let me put myself on mute. I'm going to bring up the
I know.
little clip.
They're going to be coming up with 19. I think I do.
They're going to be coming up this way. No.
Okay.
You're in pink, my love. You're wearing that. I don't think so. Yeah. Isn't that lovely that they let them park out front when they made us move all our fucking cars? And Karen can't get dropped off out front, but they get a front parking spot. How does that happen? I don't know how. Not say anything, be quiet. Thank you, Gina.
Where is it there?
Oh.
Tom DeRosa? No one's gonna yell.
Did you
Watch
notice
this.
Karen didn't get to park out front or get a police escort?
No.
I didn't think so.
Wherever you want. Straight up there. Straight up. Straight up in the Justice for John. Justice for John. Justice for John O'Keefe.
Hey Murky, do you have a link to the Turtle Boy like 40-minute video?
Yeah, so there is. So
Set up?
Karen gets to park wherever in the whole fucking around the courthouse.
I love
And
fucking Dina.
John
Hell
Finley
yeah,
gets to park
baby.
right out front with a police escort right inside.
Drop that motherfucking F-bomb.
You tell me, folks. You tell me.
Oh, I can't even know.
And yes, we all want justice for Officer John O'Keefe. I make sure I say it each time.
So Murky, do you have the link for? I'm trying to pull up. Actually, I'm going on Turtle Boy's page. I want to pull up his version of his quick, like, hey, he made this awesome recap, and I thought I saved it under my importance. Let me double check here. Speaking of important stuff, Sheldon Jeter Jr.'s got some important stuff coming up, and let me go to my channel. Oh, right here. I think I got it. This is my.
All right, you guys.
All right, here. This is the Sheldon coverage. I want you guys to see.
And found the house in Gulf Park. Again, welcome to the transparency, as this is.
Okay.
It has torn them apart. In 2018, Sheldon Jeter Jr. was questioned in connection to the Mother's Day shooting of teacher Rachel Del Tondo. In 2020, police say Jeter shot and killed his own cousin. He was later sentenced to life in prison, and now he's appealing that conviction.
This is the case that I work with the family.
Spoke exclusively to Channel 11's Nicole Ford. She filed this report before heading to breaking news.
Oh, there you go. From the very start, Sheldon Jeter Jr. was in a football uniform, headed to perform big on the field at Aliquippa.
I was just looking at one of his little things that he wrote. I was like, if he was here now.
It's these memories of her firstborn that brings a smile to Delcia Flanagan's face. Looking back, she now sees where things changed for her son, Sheldon.
It started at the elementary.
So I was able to get NBC Channel 11 to do this story to say, hey, we got to stop being one-sided here. What you guys think is the truth is not the truth. Can we please get some fair coverage? Okay. So Nicole Ford did an amazing job. And this is the work that she did and put together. And I said, if you can do this, Delcia will speak with you. And I told Delcia that I trusted Nicole Ford and that she's going to have integrity and she's not trying to put out like a hit piece. This is an opportunity for, Sheldon and his family to be heard. So this is Delcia. This is Sheldon's mom.
Elementary school when Rachel Del Tondo stepped into my son's life.
Del Tondo was a teacher who years later was found to have a relationship with Sheldon when he was just 17. Del Tondo was gunned down on Mother's Day in 2018, a case that made national news and one Sheldon Jeter was questioned in, but never charged. 2 years later, Sheldon's cousin Tyreek Pugh was shot and killed. Sheldon was convicted and sentenced for the murder.
I don't feel that it was justice. And I don't think that justice was served for my side of the family, for the Pugh family.
Flanagan believes the high publicity of the Del Tondo case convicted her son before he ever had his day in court. Now, a year later, Sheldon is getting an appeal hearing after alleging misconduct by a juror who was Del Tondo's next door neighbor. New information also came to light about other members of the
That's who broke the story for the juror. I don't know if you guys recognize this
jury.
person.
There was juror members that were talking to each other, laughing, and it's here in notes. That type of conduct can't happen.
In a multiple-page affidavit, Sheldon's appellate attorney plans to ask a judge on Tuesday morning to take the next step for Sheldon to get a new trial.
That's just right. That we get this new trial. And I'm able to do things last night.
Nicole Ford, Channel 11 News.
And tonight, a Scott Township man is accused of murder. Is under the age of 8 into his house, according to police paperwork. The boys are playing.
Oh, the reason it's recorded the way that it is because I was recording with the family from, I think it's on here. Where is it at? I was watching it with the family there, and so that's how I did it live. So
Tuesday morning to take
Sheldon's gonna get his day. So thank you so much. Lady Di sent that. So I'm gonna play now the Karen Reed little piece from Turtle Boy. But thank you so much there. I want to say that right. Osana. I don't know. Okasana. I don't want to say that wrong. Thank you so much. So there's movement happening in Sheldon's case. He's having his evidentiary hearing, and there's proof within that discovery that Sheldon Jeter Jr. is innocent as all could be, that he was framed. His lawyers didn't even file one motion. So when I see the work that Karen Reed's team does, when I see the work that Richard Allen's team does, if Sheldon Jeter Jr. just would have had 1/100th of that type of advocacy, then he would never have been found guilty. His lawyers, who were not publicly appointed, who got paid by the family and pastors in the community, church-going people, I have no idea what they thought that they could do and not do any work. They didn't even open up that discovery. So to see the work that Richard Allen got with his team, and you see the work that Karen Reed is getting, if Sheldon would have just gotten 1/100th of that, like literally, he would have never went to prison. Never. Sad. But here I'm going to share now as we're waiting, because we have 15 minutes here before Karen Reed's hearing starts. So I want to play this first 15 minutes for you guys to know the backstory of Karen Reed if you're just joining us from watching something else. So, all right, let me, let's go here. So those of you guys that have been following ever since my Aliquippa days, that's been since 2021 when that trial was. And then started working exclusively with the family to see to it that that we have to right this huge injustice. Okay, here we go. All right, let's go like this. And now let's share. Here we go. Karen Reed. This is like what I think is the best, recount of it.
I've been investigating the death of John O'Keefe from Canton. I'm Aiden Carney of Turtle Boy Daily News. I've been investigating the death of John O'Keefe from Canton, Massachusetts. His girlfriend, Karen Reed, is charged with his murder.
Karen, just to be clear, you didn't do it.
That's the view it would have gotten.
But is there something more going on here? Is Karen Reed the victim of a massive cover-up? During my investigation, I have uncovered a town full of corruption. Here's what I believe happened, and why I believe Karen Reed was framed.
Don't you want to ask some questions? I know you do.
I do. I
know
have
you
been.
do.
I have.
You think that you could outsmart Karen Reed? Did you?
It's. How can you wear those buttons when you covered up his murder? Any comment on that? Why you Googled that 227? On the morning of January 29, 2022, Boston police officer John O'Keefe was found dead outside of the Canton home of Boston Police Sergeant Brian Albert on 34 Fairview Road. O'Keefe's girlfriend, Karen Reed, was charged with manslaughter after reportedly backing over O'Keefe with her car after she got into a fight with him and dropped him off at Albert's house after a night of drinking. She was castigated widely as a cop-killing villain, set to face decades in prison. But as it would turn out, at least a dozen people were in the house when John O'Keefe was being violently beaten to death before hatching an elaborate plot to frame Karen Reed for killing him. The cover-up was aided and abetted by members of the state police, the Canton Police Department, and the Norfolk County District Attorney's Office. This is the story of one woman alone, facing down some of the most powerful, well-protected people in the state who sought to destroy her life and exonerate herself. This is Karen Reed and John O'Keefe. Karen is an intelligent, successful accountant and college professor with not even a hint of a criminal record. She'd been dating John O'Keefe for several years and loved his niece and nephew, who he adopted after both of their parents, including his sister, passed away. She owned a house in Mansfield that was rented out, but lived with O'Keefe and his niece and nephew at his home on One Meadows Ave in Canton. O'Keefe was a well-liked veteran, 16 years on the force of the Boston Police Department. On February 2nd, Reed was charged with killing John O'Keefe. Only with manslaughter, though, and she may have actually believed she was responsible. 4 months later, in June, the charges were upgraded to murder, despite no real evidence coming out that added to the story. State Trooper Michael Proctor wrote the criminal complaint for her arrest, noting his 10 years of experience on the State Police Detective Unit at the Norfolk County DA's office. The charging documents state that Canton officers Seraph and Mulaney were dispatched at 6:04 a.m. on January 29th to 34 Fairview Road, where they found 3 females: Karen Reed, Jennifer McCabe, and Kerry Roberts, next to the body of John O'Keefe. Karen Reed was performing CPR. Jennifer McCabe is pictured in this photo on the right, next to her sister Nicole Albert, who is the wife of well-connected Boston Police Sergeant Brian Albert. Brian is on the fugitive apprehension team. He is a trained MMA fighter, and he was featured on the cop show Boston's Finest. At 11:30 a.m. on January 29th, Trooper Proctor interviewed Jennifer McCabe and her husband Matthew McCabe, along with Brian Albert and Nicole Albert, comfortably at the home of Jennifer McCabe. They told him that they were out at the Waterfall Bar in Canton, where Jennifer McCabe met up with her friend John O'Keefe and his girlfriend Karen Reed, who she did not know very well. The connection between them was that John O'Keefe's niece was good friends with Jennifer McCabe's daughter. Trooper Proctor was allegedly told by Jennifer that she saw Reed enter the bar carrying a vodka soda drink in a glass, which most bars would not allow, and indicated that perhaps she was drunk. The 3 grown adults in their 40s left shortly after midnight to go to an after party at Brian Albert's house. According to Jennifer, she got there first. At 12:30, she says that she witnessed Karen Reed drive up in her black Lexus SUV. Since O'Keefe only knew McCabe at this house, he texted her to make sure that she was there. Jennifer claimed that John O'Keefe never entered the house, so she texted him hello at 12:45 before witnessing Karen drive away in her black SUV. We would later find out that most of that was a lie. She told Proctor that she assumed that he and Reed decided to go home. Jennifer received a phone call from a distraught Karen at 4:53 a.m. looking for O'Keefe. Jennifer, who for some reason was still up at 4:53 a.m. after a night of drinking, told Trooper Proctor that she offered to help Karen look for John O'Keefe along with O'Keefe's friend Kerry Roberts, who was not at the house that night. Karen was hysterical and could not drive in her condition, so Kerry drove both of them. Jennifer claims that during the ride, Karen said, quote, "Could I have hit him? Did I hit him?" She also told the state police that Karen's SUV had a cracked taillight. The 2 of them then jumped in Kerry Roberts' car and they drove back to 34 Fairview Road. When they got there, Karen immediately noticed O'Keefe's body outside, but the other 2 did not. This was part of the reason that Karen was charged. Trooper Proctor believed that Karen knew exactly where the body would be because she knew that she ran him over and left him to die during the middle of the snowstorm. We later recreated this scene at 34 Fairview Road. John O'Keefe was 6'2" 217 pounds. His body was found exactly 12 feet from the curb. There are no obstructions blocking anyone from seeing him. It would have been physically impossible for Carrie Roberts and Jennifer McCabe not to have seen his body because they were sitting in the front. They were also specifically looking for a body at that time. And somehow they claim that they did not see him, but Karen Reed did, and this ended up implicating her. O'Keefe's arm had 6 bloodied lacerations, and his eyes were swollen shut in black and blue. His eyelid had a cut on it, and his clothes were covered in blood and vomit. A medical examiner said that he had 2 swollen black eyes, a cut on the left side of his nose, a 2-inch laceration in the back of his head, and multiple skull fractures. There is no possible way that he could have these kinds of injuries from being backed into by his girlfriend's car, especially since the snow and grass would have comforted his fall. Carrie Roberts told Trooper Proctor that Karen Reed was drunk and hysterical when she saw her at 5 a.m. and stated that she was so drunk she didn't even remember going there. Carrie repeated the same story as Jennifer, that Karen made statements suggesting that she may have accidentally hit him or that he had gotten hit by a plow. At 4:30 p.m., Trooper Proctor claimed that he went to the home of Karen Reed's parents in Dighton and claimed to have observed her SUV parked in the driveway with a shattered taillight. We would later find out that this was untrue. Call logs from the Dighton Police Department showed that Trooper Proctor actually called for a tow truck at 3:02 p.m. before he had ever allegedly even seen the broken taillight and thus would have no reason to tow the car. We also have footage from Karen Reed's parents' house showing the car being towed at 4:12 p.m. ADA Adam Lally would later blame that on daylight savings, even though alarm.com
Lies.
automatically resets for daylight savings.
Lies.
This proves that Trooper Proctor was lying about what time he took the car, leaving him alone with the vehicle unaccounted for at least 1 hour and 18 minutes. Proctor interviewed her, and Karen denied bringing a drink into the Waterfall bar. She said that she dropped O'Keefe off at the party at 12:15, but since she didn't know anyone there very well, she was feeling sick, and she was a grown-ass woman in her 40s who doesn't go to after parties and play beer pong, so she elected not to stay. She lived with O'Keefe less than 3 miles away, so getting home wouldn't be a problem for him. Proctor claimed that Karen told him that she never saw O'Keefe go inside the house and had no idea how she had a broken taillight. Both of these statements made her look guilty. When she found O'Keefe's body later, his eyes were swollen and he was still bleeding from the nose and mouth. Karen attempted to call and text John O'Keefe multiple times after dropping him off. He would never knock him home, knowing his niece and nephew needed him in the morning. Trooper Proctor asked her leading questions designed to incriminate her about whether or not she had ever been in an argument with O'Keefe, and there isn't a couple on earth that hasn't been in a fight before. So Karen felt it was normal to tell Proctor that they had an argument over breakfast. This is why you should never talk to police without a lawyer if you're a suspect in a crime. They are not there to be your
Period.
friend. They are there to get you to say something that will lead you to being charged criminally. A Canton firefighter, who we later found out was good friends with Caitlin Albert, the grown daughter of Brian Albert, who was inside 34 Fairview Road the night that John O'Keefe was killed, was one of the first responders to the scene. She told Trooper Proctor that Karen said to her friend, "I hit him," quote unquote, several times, further incriminating herself. Proctor's report also states that 2 red pieces of taillight were next to O'Keefe's body, which was the final piece of evidence needed to charge her with manslaughter. Except in the original report from the Canton Police Department, it never mentions anything about any taillight, and only 2 inches of snow had fallen at that time. As a matter of fact, the only thing that they found were droplets of blood, which they kept in red Solo cups, and some shattered cocktail glass, which apparently Karen Reed hit him with before backing into him with her car and killing him. Sure. But Trooper Proctor never once mentioned that he was a close personal friend with the McCabe and Albert families, which were prominent names in Canton. Here's a picture from Proctor's sister's Facebook page showing Trooper Proctor with Jennifer McCabe's children. ADA Adam Lally would later contend
the child that's depicted in that particular photograph is not one of the McCabe's children.
Oh, really?
McCabe's have 4 daughters. That's not one of them. It's a relative.
Indeed, he does have his arm around his niece. However, there are 2 girls in towels and bathing suits directly behind him who are, in fact, Jennifer McCabe's children. Here's another picture from Proctor's sister's Facebook page showing her at a family party with Chris Albert, the brother of Brian Albert, directly behind her. Chris Albert was at the bar with O'Keefe the night he was killed, and he owns a local pizza shop in town called D&E Pizza. It's unknown if he was inside his brother's house that night because Trooper Proctor has deliberately prevented Google from sharing geofence data that could provide that information.
Ooh, what does that remind you of?
7 Meadows Ave in Canton, 3 doors away from John O'Keefe.
Geofencing being what? What? Same thing like the Delphi case, right? Huh?
Who lived at 1 Meadows Ave. Chris's son, Colin Albert, was an 18-year-old senior at Canton High School at the time of the incident and is confirmed to have been inside the house at 34 Fairview Road that night. Colin was a star football player at Canton High School and a notorious hothead. There are multiple videos that we have posted of Colin in which he's threatening rivals in town and even ends it with bang, bang, which apparently is supposed to scare you into believing that this man will kill you. 2 days after John O'Keefe died, the Canton High School Twitter account announced that Colin would be playing football at Bridgewater State next year. Colin is an out-of-control meathead who frequently was confrontational towards his much older adult neighbor, John O'Keefe. He constantly trespassed on his property, threw beer cans on his lawn. He is the prototypical jock who thinks that Shakespeare was a huge loser and infamously poses for pictures sticking either his middle finger up or his fist in the air while pounding down Dylan Mulvaney lights. Colin has anger issues and gets off on knowing that he comes from a well-connected family in town. His uncle Brian, of course, is a Boston police sergeant. His uncle Kevin is a Canton police officer. His father, Chris, was recently elected to the Board of Selectmen. Here he is on the left, pictured with his father and his uncle Brian on the far right. The man in the middle is his other uncle, Tim Albert, the family moron who takes pride in being from a well-connected family despite providing nothing of value to contribute to the family's brand name. Trooper Proctor's family knew Colin since he was a little boy. Here he is pictured with his Michael Proctor's sister once again. Here's another picture of Proctor's sister she posted on Facebook from her 2012 wedding, showing Trooper Proctor on the far left and Colin on the right as a 7-year-old boy. They were both in the wedding party together. Not once did it ever occur to Proctor to mention that he was a close friend to a well-connected Canton family of cops and politicians and was investigating the death of a Boston police officer at one of their homes. He was in possession of all evidence to this crime and decided who would, and more importantly, who would not be investigated.
There is no conflict. Proctor is not conflicted in this case. I indicated that.
Colin Albert likes to get in fights and boast about it. A picture he posted on Visco shortly after the death of John O'Keefe shows his right knuckles covered in abrasions, indicating that he had punched someone or something recently. None of this has been made public, and the Norfolk County District Attorney's Office hasn't sent.
In trial, he said that he stopped his fall. He was falling and he was holding something and he stopped his fall with his knuckles. That's what he said in trial, just so you guys know.
A mountain of exculpatory evidence to Karen Reed's defense attorneys until recently. This evidence that they've withheld includes DNA evidence from John's body that could prove whether or not a dog had bitten him, for instance, as well as a 2-minute video clip from the Canton Library, which would have shown whether or not Karen Reed's taillight was broken after dropping John O'Keefe off at 34 Fairview Road. Because if it wasn't broken, that means that she didn't.
How crazy is that? With the library footage, right, in this case. And then in the Delphi case, I was over there saying, why didn't they get the library footage from the library where Betsy Blair said she went to take a 21-minute piss?
Hit him with her car. This evidence proves beyond a shadow of a doubt that she had nothing to do with John O'Keefe's death, but suggests that Colin Albert, Brian Albert's German Shepherd Chloe, Jennifer McCabe, Matt McCabe, and every other person in that house either witnessed or knew about the murder of John O'Keefe and conspired to frame Karen Reed after the fact. Unfortunately for them, Karen Reed is an extremely intelligent and well-resourced woman who can afford world-class representations. She initially had an attorney by the name of David Yannetti, a well-respected Boston lawyer with more than 30 years of experience, who used to be a prosecutor. However, Yannetti can only do so much, and Karen Reed quickly realized after time that she was up against some powerful forces and she would need more representation, particularly when it came to cell phone expertise, which a lot of this case hinges on. So she did some searching and she found a guy by the name of Alan Jackson from Los Angeles who had previously represented a man by the name of Kevin Spacey in Nantucket. Kevin Spacey was accused of sexually assaulting an 18-year-old bartender, but later we found out through the use of forensic technology that the quote-unquote victim and his mother had deleted a number of incriminating messages that showed that the boy was not actually a victim at all. Her attorneys filed a motion demanding a forensic audit of Jennifer McCabe and Brian Albert's cell phones and for all communications before and after O'Keefe's death. However, to this day, they have not gotten Albert's cell phone. Jennifer McCabe, on the other hand, voluntarily handed over her phone, thinking that if she deleted enough information, location, no one would find it. And indeed, that initially worked. State Police Detective Nicholas Guarino claimed to do a full extraction of her phone, and nothing really incriminating came back. But it didn't smell right to Alan Jackson. So they did another search of her phone, and they hired a man by the name of Richard Green, an expert in his field. And Richard Green did a much more thorough and expensive search into Jennifer McCabe's phone. What they discovered in April was shocking. They found that the Norfolk County DA's office intentionally hid evidence showing that Jennifer McCabe had searched, quote, how long to die in cold, except she spelled it H-O-S. How long to die in cold.
How long?
At 2:27 a.m. on the night that John O'Keefe died. Well, how could she do that if she thought, why would she do that? More importantly, if she believed, as she told Trooper Proctor, that John O'Keefe had gone home and gone to bed, why would he possibly be dying in the cold? Unless, of course, the plan was to put his body in the cold so that he died from hypothermia.
How can you wear those buttons when you covered up his murder? Any comment on that? Why you Googled that at 2:27? Any comment, Mr. McCabe?
Brian Albert was never questioned at his house, only at the McCabe's house, which was interesting because a dead body was found in his yard. Canton Deputy Police Chief Tom Keller happens to live across the street from Brian Albert on Fairview Road. He has a Ring camera that would have picked up video of O'Keefe's body being hit that night.
That's the view it would have gotten.
That's the exact view. Wow. However, he told police that conveniently he did not capture anything of value on his Ring camera. It was never subpoenaed. Jennifer McCabe not only searched for how long to die in cold, she also deleted all communications on her phone between herself, Brian Albert, and her sister, Nicole Albert. If Jennifer McCabe didn't think it was unusual for John O'Keefe to leave, then why did she stay up until 5 a.m. awaiting Karen Reed's phone call about John O'Keefe being missing? If Jennifer McCabe had nothing to hide, then why was she destroying critical evidence around the time that John O'Keefe's body was discovered? Why was Jennifer McCabe more committed to protecting Brian Albert than her sister Nicole, who was married to Brian? After O'Keefe got to Albert's home, he began texting McCabe to make sure she was there, since she was the only person he knew well, or at all. When he entered, he was surprised to see 18-year-old Colin Albert was there, who likely confronted him at some point and hit him, according to the theory proposed by Alan Jackson and David Yannetti in their court filings. Our sources believe that Brian Albert joined in on the beating, alarming his loyal German Shepherd, which immediately began to tear into John O'Keefe's arm. Despite being their family dog, Brian Albert got rid of Chloe and never explained where the dog went. The defense team has since filed motions to try to get animal control records about the dog, which for some reason the ADA's office objected to. Unfortunately for him, the defense won their motion and the records were impounded. And as I speak right now, they are still trying to get those unimpounded. A motion has been filed on June 7th for that. Definitely in that house that night were Brian Albert, Nicole Albert, Brian Albert Jr., Colin Albert, Caitlin Albert, Jennifer and Matthew McCabe, friends of Albert Jr. named Julie Nagel, Emily Fabiano, and Sarah Levinson, and an ATF agent named Brian Higgins, who has an office inside the Canton Police Department. O'Keefe would make 12 at a minimum. We have one picture of Higgins with O'Keefe, who was with Brian Albert earlier in the day in New York, and they had driven back after a police officer's funeral there, and they've been very chummy since then. This means that all of these people either witnessed the murder or somehow had no idea that a murder took place in a house they were in, and they've said nothing. Not one of them claims to have seen a 6'2", 217-pound body lying on the front lawn after leaving. One witness named Ryan Nagel went to the home to pick up his sister Julie, who ended up staying there. He was the only witness who had no familial ties to the Albert, and thus no reason to frame Karen Reed. He said that he witnessed Reed outside of the house. They arrived on Fairview Road at basically the same time, coming from different directions. He yielded to her. He allowed her to turn right onto the street. Now, keep in mind, it was snowing and visibility was difficult. So Karen Reed pulled up in front of the driveway, and she claims that John O'Keefe got out and ran into the house. She then pulled up a little further along the left-hand side of the property and said said that she was beginning to text him because he was supposed to text her back to let her know everything's all set. You can go home now. Ryan Nagel has all but confirmed that this is exactly what happened because according to his own testimony, he said that he didn't see any damage to her vehicle, never heard any screams, never witnessed her operating the vehicle erratically. And when he drove by her, most importantly, she was alone in the vehicle and her interior lights were on. Her hands were at 10 and 2. Yet John O'Keefe's body was not on the ground. So where could he be if not inside the house? Additionally, O'Keefe's phone tracked him walking up and down the stairs, ascending and descending inside the Albert home from 12:21 to 12:24. Obviously, it would not show this sort of up and down motion if he was inside Karen Reed's car or lying on the ground outside the home. And remember, the cell phone says he's in there between 12:21 and 12:24. Jennifer McCabe said he did not arrive there until 12:30. State police and the DA's office deliberately kept all of this information from the defense, including Jennifer McCabe's incriminating Google search. Jennifer McCabe's cell phone analysis shows that she left the Albert house at 1:47 a.m. with Matthew McCabe, Julie Nagel, and Sarah Levinson. Alan Jackson asserted in his filings that she gave the other two a ride home because they lived near Meadows Ave and she wanted to drive by John O'Keefe's house to see if Karen Reed was up to understand whether or not they had time to get rid of his body or whether or not she was up wondering where he was. So she dropped them both off at 2:27. Her Apple Watch recorded her going to her bedroom and Googling how long to die in cold, despite previously telling police that she assumed that John O'Keefe had gone home with Karen Reed. Why would she Google that if she thought he was home sleeping? A normal person after a night of drinking would be sleeping at 2:30 a.m. McCabe, instead of going to bed, elected to pace around her house nervously. That's what the Apple Health data shows, waiting for Karen Reed to contact her and ask where O'Keefe was. Somehow she anticipated this happening despite allegedly having no idea that John O'Keefe was missing. McCabe waited up for Reed because, number one, she needed to be with her when Reed discovered the body so that she could control the narrative with the police. And number two, she needed to put the idea in Reed's head that she might have accidentally hit and killed John O'Keefe while driving drunk and had no recollection of it. Reed truly believed that she might have done this and was distraught. His body was staged at the exact place where she was seen dropping him off before leaving. Although it is interesting that they claim that she did a 3-point turn, but only Michael Proctor claims that. He claims that Reed told him that she did a 3-point turn, except that makes no sense. That, of course, would be the only way that she could have backed into John O'Keefe is if she did a 3-point turn. If she just kept going straight south on Fairview Road, then she couldn't have backed into him. Both Jennifer and Matt McCabe claim that is the exact direction that she went in, was south, that there was no 3-point turn. Despite barely knowing Karen Reed, Jennifer McCabe gleefully jumped in the car with her and Kerry Roberts. It is believed or asserted by the defense that this intentional delay guaranteed that O'Keefe would be dead by the time anyone found him. Remember, how long to die in cold, and that he would be unable to tell the real story about what happened. It is important to point out that when John O'Keefe was put outside to die, he was still alive. They did this so that the medical examiner could say that one of the causes of his death was hypothermia. Remember also that Jennifer McCabe initially told investigators that Karen Reed brought in a drink from another bar to the Waterfall bar, which only a drunken, low-class individual would do. But Karen Reed had a good job and made good money. Why would she do such a thing? Nevertheless, McCabe successfully planted the seed in Reed's brain that she may have accidentally killed O'Keefe. Jennifer McCabe also deleted phone calls to her sister Nicole Albert at 6:07 and 6:08. Those are now gone. They were 7 and 9 seconds long, and someone answered that phone. Now, ADA Lally has since claimed that that's evidence that the calls went to voicemail, except only unanswered calls go to voicemail, and that makes no sense. This proved that McCabe had made them aware that there was a dead body outside of their house. There was not enough time for her to explain, oh my God, there's a dead body out here. I don't know what's going on, but there was plenty of time in 7 to 9 seconds to say, Karen Reed is here, don't come outside. This proved that McCabe made them aware that there.
And I personally believe it was we have to pass off the cell phone. So that's all the stuff that I did, is to put all the steps together and where the steps fell within the storyline of everything. And I personally believe that cell phone was passed because Jennifer McCabe's steps and John O'Keefe's steps on his phone when he is laying down unconscious. His phone starts moving almost at the same time that Jennifer McCabe's phone starts moving when she gets out of the vehicle to approach the body.
There was a dead body outside the house. Yet Brian Albert, a veteran Boston police officer and trained first responder, did not even come outside, despite the fact that there were a plethora of emergency vehicles, a lot of people making noises, blue and red lights flashing everywhere, and radios going off. And oh yeah, a screaming, hysterical woman on his front lawn named Karen Reed. A broken cocktail glass was found next to O'Keefe's body, which Canton police initially said was the murder weapon. O'Keefe's body was clearly visible, as not much snow had accumulated. Yet McCabe and Roberts didn't see it. Only Karen Reed did. After notifying the Alberts about the dead cop on their property, Jennifer McCabe Googled, quote, "How long does it take to digest food?" 10 minutes after finding a body. The presence of food particles in a dead person's stomach helped pathologists determine time of death. At this point, Jen McCabe was panicking because she knew how suspicious the "how long to die in cold" Google search was at 2:27 a.m. She decided to search for that same thing again after discovering O'Keefe's body, hoping that it would make it look less suspicious. And as this might be something a person might Google after finding a body outside. In doing so, she hoped that it would make the first search disappear. Unfortunately, she spelled the words wrong the first time she searched it, not even close to the original "Hoss long to die in cold." The second time, she spelled it the exact same way. Hoss long to die in cold. Not how. This was intentional. She later told law enforcement that it was Karen Reed who told her to Google that. Luckily for McCabe, Brian Albert's brother is a Canton cop. His other brother is a selectman. His neighbor is the deputy chief, and the trooper in charge of the investigation was a close family friend who helped cover up the murder. It was going to be covered up regardless. When you thought that Jennifer McCabe couldn't get any lower, she also has been sharing fundraisers for John O'Keefe despite helping to cover up for his murder. Jennifer McCabe goes to every single court date. She comforts the family of John O'Keefe. She has John O'Keefe's badge number decaled on the back of her car. She has blue lights in front of her house and constantly wears thin blue line stuff everywhere. She is utterly shameless. Obviously, Jennifer McCabe did not kill John O'Keefe since she's not physically capable of that, but Brian Albert, Colin Albert, and the dog were more than capable of that, and Colin Albert had the motive. McCabe was just the quarterback of the cover-up and seemed to want to protect Brian Albert more than even his own wife did. Take from that what you will. Jennifer McCabe would never have been able to cover up this murder without the assistance of law enforcement, despite the fact that it was one of their own, who was killed. According to Reed's defense attorneys, the original Canton Police Department report had been altered. In the altered report, it never stated the CERT team found the taillight at 6 p.m.
Do you guys see right there? The altered report swaps the single crime scene photograph. And I then pointed out during the trial, I was like, holy shit, this is why they had to swap it, because it's the angle of the picture that shows the curb where there is no shoe. But when the Massachusetts State Police took their photo, there's a shoe there. So they had to hurry up and get that picture off of the report. And I hope to God that the defense uses that this time, because that's why they had to change that picture. Because it was like, holy shit, this shows that there was no shoe there way earlier at 7 o'clock in the morning. And then when Massachusetts State Police took their picture way in the afternoon, okay, same spot, there was a shoe. And I'm like, and I had it put it up when I was showing the trial, put it up side by side. I was like, guys, look at this. This is why it was taken off the front of the report. Ugh. It's just so sick.
After Trooper Proctor had taken possession of Reed's vehicle. The alter report also had a different cell phone number that McCabe called after finding the body, indicating that police were taking steps to make sure that Brian Albert was not in any way a suspect. New evidence has also shown that Albert rehomed the dog that attacked O'Keefe. He claims to know where that dog is, yet they won't tell the court where it is. In September of 2022, Reed's lawyers publicly accused the Albert family in open court of being implicated in John O'Keefe's murder, and they ordered ordered them through the judge not to delete anything from their phones. 2 weeks later, Tim Albert, the Fredo of the family, posted a meme on Facebook stating, quote, "You don't fuck with my family," and that he won't hesitate to make you miserable if you do. Just a couple days after these filings were made in court, Tim Albert decided that it would be a good time in October to fill in his pool. Nothing shady about that. Tim is the loser of the family who seeks approval by virtue signaling about how loyal he is so that he can enjoy the fruits of the success while contributing nothing himself. This post was clearly a direct attempt to intimidate Karen Reed, her attorneys, and reporters like me who expose people like him for being dirtbags. After being accused in September by Reed's attorneys, Brian Albert immediately decided that it would be a good time to sell his childhood home, which had been in the family for almost 50 years. It sold rather quickly for $50,000 less than they were asking for it, and as a result was never searched by police, despite the fact that a Boston cop was probably murdered inside of it and was found dead on that property. The person most responsible for the cover-up is certainly Trooper Proctor, who failed to speak to key witnesses, protected his close friends, and never applied for geofence data that would show the identities of every person in that house that night. We later found out that he lied about what time that he arrived at Karen Reed's parents' house in order to have the car by himself for 1 hour and 18 minutes. We also found out that in his reports, he intentionally misspelled the names of at least 4 witnesses, including
Is she in
Sarah
there?
Levinson, Caitlin Albert, a woman by the name of Emily.
All right. Is Bev in there? Let me go ahead and hold on one second.
To get notice out to all the parties.
Yeah.
It's today. All right.
It's currently underway inside Norfolk Superior Court in Dedham. Several items on the agenda during the hearing today with the possibility of some being decided. Let's listen in. Good morning, Mr. McLaughlin.
For the defense?
Good morning, Your Honor. Alan Jackson on behalf of
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so we have a series of motions here. I expect we may be here a while this morning. It makes sense to me to start with the Rule 17 motions. So the first Rule 17 motion I have is the Commonwealth's motion for records from Verizon. But I do have a question for you, Mr. Brennan. Have the third-party record holders been served in all of these Commonwealth motions pursuant to Rule 17?
Thank you, Your Honor. I understand the court might have a preference that I remove from the podium. Would you like me to answer?
It's wherever you're comfortable, as long as we can hear you.
Your Honor, I filed a series of Rule 17 motions, as I'm sure you're aware. I have not notified any of the third-party holders. I did not want to be presumptuous, seeing that I have not met the court and didn't know what the schedule would be for the Rule 17s.
Oh, okay.
So I have filed these just to give everybody as much notice as possible. And my intention was to ask the court if we could set a date so that we could have these motions heard and hear the defendant's objections.
Okay. All right, so I misunderstood. I thought they were on for the Rule 17 motions today. All right, so the record holders do need to be heard. I was wondering why I did not hear from any of the parties, other than I have the defendant's objection to Mr. Reed's records. But all right, so we'll get a date, and that date should be sooner rather than later to get notice out to all the parties.
Yes, Your Honor. I'll note that we did file 2 additional Rule 17s last night. I don't know if they've been docketed.
They have been docketed. I got them, and that's why I was wondering whether the record holders had in fact been notified. So, okay, so scheduling we'll do at the end of the hearing. Then I think what we'll start with after these Rule 17s that we'll put on pause, it's paper number 48. It's the defendant's motion for relief from the order to impound sidebar conferences. And before we begin that, is there an opposition to that from the Commonwealth?
In part.
Okay. All right. Have you spoken with Mr. Yannetti about what part that is?
I've spoken to all the attorneys numerous times. I think we're very clear what each other's position is.
Okay. All right, why don't you, all right, Mr. Yannetti, do you want to be heard by starting with the whole motion or what?
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because unlike the defense team, he was not present at sidebar. He does not know what the conferences were about. And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense. Have you spoken with Ms. King about how long it will take to get these transcripts?
My co-counsel has spoken to her only.
Which co-counsel?
Mr. Jackson.
All right. What do you have to say about that? How quickly can she get them?
She works extremely expeditiously, but she has not started them. To my understanding, there's 3 reporters who probably would split the work.
Right.
And she said that she could get started as soon as there was a court order suggesting that she do so. I would imagine, given what we've gotten so far, we're talking a couple of weeks rather than a month or 2. I think we could probably get something within a few weeks.
Okay.
2 to 3, I would guess, just based on my experience with Ms. King.
All right. Even though it's just for counsel, do you intend to have, are you asking me to unseal the sidebar conferences with the jurors?
Just for counsel, yes. I would imagine that when we get to the second stage of this, those would be in a different category from the legal rulings at sidebar unrelated to jurors.
All right. All right. Thank you.
If I could be heard briefly.
Sure.
Thank you. Regarding the non-juror information, I'm in full agreement with the defense. I think it's prudent to, if the court would consider unimpounding the documents, I can review them.
Well, you can review unimpounded documents. Counsel can review impounded documents.
Then I'll begin that task. And if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside of protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC based on the request of the defense. If they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point. All the other information, I don't have the same concern.
Okay. All right. Thank you. All right. The next motion. So defendant's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing. So we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard at that time. But I'm prepared now if the court prefers me to.
No, I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to. Okay. So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together, to adequately review it, and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay. All right. So why don't we give you, so we'll give you until the 27th, just after, or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right. Does that work for you, Ms. Giannetti?
Certainly does.
All right, so let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's Lexus telematics system.
May I?
Yes.
As a matter of background, as I think the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information, information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather it was to notice them, this is what we were going to do. You can see from my motion, I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they're entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak for what their position is today, but I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility, but it was the defense expert that overlooked the proper reader that was needed for the chips that were tested, and it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights, and that's why we now have an independent expert that is going to do this. I know experts differ. They're not frick or frack. They all have different opinions, but we've attached all of the protocol, what we intend on doing. And the reason I brought it before the court is I wanted to expedite this matter. It's important, and it.
I thought we were going to have that hearing within 14 days when we first got the motion. And then Mr. McDermott told me that the defense was looking for more time, so we gave this. We're far into the case is scheduled currently for January 27th. Sounds like you had a lot to do before then, but as of right now, it's still January 27th. So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
how long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center, our system data. The problem that we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his expert was his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip off, physically did not know how to do it, it was Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former NSP officer and extremely facile in this world of
And you
chips.
have a different expert now. You're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip offs and chip ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to sort of engage in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2-micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips that didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable. It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2-micron chips and the expansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Your new response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He'd be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role and no purpose in it. And so inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these chips and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It'll provide the information that will be available to both us and the defense.
All right, so if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence. And I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly. All right, so I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Can I begin?
Yes. And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these ships in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable. I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony. They're retaining experts to counter that testimony and then to reciprocate in discovery where days, weeks, are in the midst of trial. I want to avoid unfairness to defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbers, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial. And I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing.
Have you been working on that, though, in anticipation?
We have,
Okay.
yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial. And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests, just like Mr. Brennan said. So we'd ask the court to allow this motion.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have. So we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert, I did not believe, followed the proper methodology or had the expertise to make.
All right. Does the defense intend to call Dr. I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be on this list.
All right. So why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay. So why don't we set a Daubert hearing? I know you'll have to fly her in, but why don't we get a date now in December for that?
Does the court anticipate that being a different day than the date we're going to set for the Rule 17?
Rule 17 we're doing as soon as possible. We'll do before that date.
Understood.
So we're going to need. Maybe we can have it filed on the 25th.
So, Mr. McDermott.
May I approach Mr. Brennan for a minute?
Sure. Jim, can you pull up, Jimmy? How was, it's December 10th. I think we moved both our trials yesterday.
Would the 13th of December be available for a Daubert hearing? It's a Friday.
Possibly. I think we just put something else on this morning that would be time consuming.
I could also do the 12th if Mr. Brennan's available and in my co-counsel.
I was looking at the 10th, but Jim, could you look at the 13th?
Yeah, this is the 10th.
The 10th work for both of you. The government's available on the 10th.
So I have you cannot do the 10th, okay.
Your Honor, just to be completely candid, I have nothing on the 10th. I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So I'm sorry, I'm reversing that on the 9th. I didn't fly out on the 9th. And I've got an all-day hearing on the 9th back in California, so I can't fly that day. So
Well, court ends at what time?
I'm sorry, Your Honor?
You could take, a lot of people take a red eye, right? Can you come out then?
I do every time.
What?
You can't fly out on the 9th, the evening of the 9th?
There's no way I can't take a flight on the 9th.
What about the 16th? It's a Monday. Is that?
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. Jim, we just put Gaston on for that day. Yep, we have a full hearing, and we also do on Gaston.
How about the 12th?
Let me just look at that. Did you say the 12th?
The 12th works.
I can do the 12th.
I can do the 12th.
We'll accommodate, yes.
All right, so the Daubert hearing will be December 12th.
That'd be at 9 o'clock, Your Honor.
Yes.
Oh my gosh.
All right.
Bev is something else, man. But she's an angel compared to Gall.
We'll get a date on that in just a minute, Jimmy.
Everybody takes a red eye. Can't you take a red eye? I do every time.
When are you available for the Rule 17 motions? How about November 26th?
Thank you. Bless me.
Um,
Okay. Don't you think Alan Jackson's like, can't we just have all of this shit on one day?
Where?
In Woburn District Court. To the extent that the court would give me a protective order, I can do that.
Or tell them that you have a trial here, and if I need to speak to anybody, I will.
Okay, appreciate that.
We're not a trial here with this motion hearing.
Okay.
I'd like to do it as soon as possible to get those out, get that moving.
Thank you.
So November 26th, Jim, can we do that in the morning?
Yes.
Okay.
I'm told that Mr. Jackson cannot make the 26th.
For the Rule 17 motions, do you need to be here in person?
If I could have 10 seconds.
During this moment, if I could just alert the court that there is one additional Rule 17 I'll have filed by Friday. It is similar to a number of.
File it and send notice immediately of the date.
May I inquire, do I send notice on behalf of the Commonwealth, or does the clerk's office send it?
Mr. Lally can inform you on the process, but
Thank you very much.
send it right out.
We will. Thank you.
Mr. Lally, because he's just so efficient.
Yeah, we'll make the 26th work.
Great.
I likely will not be here, but she will
Okay.
be right there.
Are we 9 a.m.?
Why don't we do 10 a.m., Jimmy?
10 a.m. on
Get
the
all the
26th.
record holders who want to be here.
10
10
a.m.
a.m. on the 26th.
November 26th.
All right. And all the other motions are taken under advisement.
Great.
Okay. Thank you very much.
Thank you.
All right, please.
That's my
Mr. Clerk, whenever you have a minute.
You are muted.
All right. Well. Good old Bev. Love seeing Bev back in action, man. Look at that. Look at her bangs. See that blowout. Where's that blowout? There she is. Oh, what the heck? There she is. Look at there. Mm-hmm. Good, nice close-up of our girl. I've missed our Bev bingo blowout. Look at those bangs being blown out perfectly, Cheers to Bev. So, well, so the Rule 17, you guys, they're looking to get Bill Reed's cell phone, but now in this hearing, we just found out that he has a couple other phones I think he's interested in. That is what I gathered. So the first thing that was up was they want to get the sidebar transcripts, everything that happened with the sidebars, to have those transcribed. And it is solely right now just for counsel at this point. So as far as like unsealing it, we wouldn't be able to get it, but it would be for the lawyers. That was the first thing. Then, he did the oral arguing here for the for the defense in terms of, again, they want that November. So they must be switching from November 27th to November 26th at 10 a.m. because they were looking at right before the Thanksgiving break. The big thing is they want to retest this Lexus, Karen Reed's Lexus. So the Commonwealth has hired a new expert. So Joe Paul is no longer, Trooper Paul is no longer their expert. He wasn't an expert to begin with, but they hired an independent expert, and it's to go for, let's see, there's obviously information missing from it, the navigation system, phones that would have been plugged in, travel logs. It was not fully downloaded. So there was a ton of data that is missing, and it's there. And, then they're missing up gigabytes bites, bits. I mean, he's saying that, hey, this stuff could be inculpatory or exculpatory, for Miss Reed. So it's not just like we're doing this for us, but we're doing it also for her. They only took out one board. There was actually 3 boards in the Lexus. They got a search warrant for it. And basically he's like, I'm just notifying the defense. I don't have to ask them for their permission. We're going to go ahead and do this. So it was more like I'm not asking them for permission. I'm just notifying the defense. So the defense then stands up with Alan Jackson. And the defense hired an additional expert, not somebody that's, you heard his wording there. Where he's like, no, I didn't hire a new person. Like we hired an additional expert. One that is very, very good with, he's a chip in and chip out guy. He's really good with that. He says his resume speaks for itself pretty much. So just to be clear here, it's a 3-day testing, and then it would take a week to read it, the testing. Yeah, they're trying to expedite this. The defense says, let's just be clear here. We have no objection to retesting anything. Our issue is that we want to make sure that nothing is destroyed, altered, that what we have here, and he just said, he threw out an example, Alan Jackson did. He's like, we want to do a checksum here, which is if there's 5,123, he just threw out a number. He's like that it's reading now, that nothing, that when it comes back, it has 5,123 that is read then, which is just a checksum. And he said that we just want to make sure there's no data missing, his new expert, you're basically gonna have to resolder them, put them back onto the Lexus, then turn the Lexus back on. He's like, we want this work done. We just want to make sure that it does not delete anything. Then prosecution says, well, this testing is potentially destructible. Like that is a risk. He said, I did talk to my expert this morning, and he said, we can probably get to it, be done December 2nd or the 3rd. He's like, that's not good enough. We need this done before Thanksgiving. I have to finish up that conversation. And then they did their joint motion, like saying, hey, we want this, Gull's over here, or Bev's over here saying, well, you guys are already assuming that I'm going to be approving this, continuation of the trial with this joint motion, because both sides want to see that it moves back. It's like about 2 months. So February and March, so as if it went at the end of January right now, they're essentially just asking for a 2-month delay. And something that's interesting that the prosecution says is that they are going to be significantly reducing their witness list. So also, they want to make sure that all the testing is done. The experts have their reports in, that there's reciprocal discovery. In order to get reciprocal discovery from the defense, we have to give them our stuff, and that's the only way that we can get reciprocal discovery. So he's over here not saying a word about Lally and anything that he's ever done. He's like, I brought in my own paralegal. Lally can't even do the paralegal work. So he brought in his own paralegal. They're relabeling the discovery. Okay. And he made a note to say, like, hey, anything that comes into my office, even emails from strangers online that are talking about theories, he's sending them to Alan Jackson. Wild. So anybody that's emailing the prosecution, Alan Jackson's receiving those emails through discovery. So they just need this extra time. both sides. They believe that this will expedite the actual trial, that they are not expecting as long as a trial. So yeah. And there's just simply not enough time. And then the defense got up there with Yannetti saying that, we just care that Miss Reed has, she has a right to a fair trial, and that granting these 2 additional months is essential for that. And then the Dauber hearing, the last thing to be talked about was basically the prosecution is going to go after the ER doctor that testified to the dog bites. And that's a hearing that's set. There's a hearing that's on December 12th for that. And then but the next hearing is November 26th at 10 a.m., which Ellen Jackson won't be attending, but Little will be, from my little whispers that I heard. But they were going to try to get that ER doctor, Dr. Russell, to not be able to be considered. So that is the sum up of all of that. I'm curious to see what's been going on with the defense wanting the emails, the burner email that's possibly been used by the DA to communicate with ex parte communication with judges and other people. So I'm curious what's going to come of this, of what's been going on with Turtle Boy stuff, because Turtle Boy's discovery has, I guess you could say, Karen Reed's defense has obviously been looking at that, and they're being given that. And then from that, is there stuff that we can use out of that? Can we go and, get things that they said that they weren't there, and actually they are there? I mean, it's a mess. It's an absolute mess what's going on over there. The DA's office is a complete fucking mess. That's what it is. I don't know. I think they wanted to hold off personally for the defense. I think they're trying to get more shit. I think as time goes on here, then, the more things that Turtle Boy gets his hand on from his case that they can turn over, to Karen Reed's defense. Remember, they were on this war path to try to get a grand jury indictment on Turtle Boy and Karen Reed for witness intimidation, if everybody remembers that. Wild, but curious to know what the feds are doing. I mean, how do you get a jury in that area that doesn't know this case, to the point of that they didn't watch the whole first trial, to come on and sit on this jury? This isn't going to get moved. So what's happening here? Explain that to me. I don't know. Explain that to me. Sheesh. I also want to ask, Colin Albert totally committed perjury. Absolutely committed perjury. Okay. He's on the stand. He says, I never fought with anybody except for my brothers. Okay. Then boom, goes off the stand. Then all these videos surface of literally Colin Albert fighting. So the prosecution can reduce their witness list. All right. Remember, this is a whole new trial, so we're going. I mean, is Karen Reed going third party culpability? Are they going to try to do that again, or are we just going to like poke holes at the state's case? Is Trooper Proctor going to testify? What side is he going to be called by? I mean, I think the repetitive stuff that what he's saying, the prosecutor is saying here, is that we're going to be reducing our list. Like, what the repetitive stuff that you don't need to have 5 firefighters testify. The fact that you don't need, I mean, I think calling Colin Albert back to the stand is imperative to ask him why he lied to the jury the first time. Like, here, you testify, this is what you said, here's your transcripts. Then, not even a day later, these are the videos that surface. Are these you? I mean, so why did you feel the need? Why couldn't you just say that, yeah, I fought? What kid hasn't fought? Why lie about that? That's what's just mind-blowing to me. And then how is that not relevant? How is that not relevant? You're going to sit here and tell me that Karen Reed's attorneys aren't going to be able to ask Colin Albert why he felt the need to lie? Like, you have nothing to do with this. You weren't there. You could fight every single day of your life. Who cares? This is going to be wild. The second trial, I feel like, is going to be, I mean, what if there's exculpatory evidence on the Lexus that shows that Karen Reed didn't do it? Are you going to drop the charges? Is this like a possible play up to that? That, oh wait, the Lexus shows that it didn't happen that way, and so therefore now we can. That's how we're gonna drop the charges. Based off of the juror interviews that Turtle Boy did, how is the defense taking that? And do you think that the defense is taking that into consideration on how they're going about preparing for trial 2? I know that I wouldn't mind saying that the Lexus basically, oh, look at this. It shows this. Hey, this is how we're gonna get out of this. We're gonna drop the charges based off of the Lexus findings. I mean, I know the jurors were asking for a cert report, remember? And there is no cert report, remember? That's not going to change in trial 2 because there is no cert report. So wouldn't the defense want to be like highlighting that in this trial to talk about, like, or to make it known that the report that's considered the cert report is whatever Tully wrote up? I mean, I think that Tully nobody went at Tully at all. Like, I think that, I mean, Tully, I think could be on the stand for 2 days. How about who inverted the fucking video? Who inverted the video? How do we not know who inverted the video? Is that going to come out in trial 2? It better come out in trial 2. Who inverted the video? Does anybody know who inverted the video? How is that? And then this is like one of those moments you're like, well, how is it admissible? But then it's like you want it to be in because then you want to show why they inverted the video, right? They inverted it to make it seem like they didn't do anything, right? Who inverted the video? Who had access to the video? When was the video inverted? What are the dates of the dates of that? Okay. When was the video inverted? Who decided to invert the video? What was the purpose for inverting the video? You don't think that these are questions? We didn't get any of those questions. I don't care if you have to sit there and call all these motherfuckers to the stand and ask them one question. Did you work on the video in the Sally port? No more further questions. Next witness, we're going to call every motherfucker from Canton Police Department that worked there and had access to like literally get in that building. And like let the juror sit there and hear that every single person is saying no. Unless somebody's lying, you guys. Because a fairy, little fucking tooth fairy didn't do it. Maybe that's how you go about it. Call each one of the people and ask them one question. Did you work with the video from the Sally port? No. Do you have knowledge of who worked with the video? Do you have personal knowledge? No. Okay, no more further questions. Next person. Bring these motherfuckers in. Sit them down. Okay? Have one day that you go through the whole damn Canton Police Department, and then you say, well, guys, the video was inverted, and nobody here is taking ownership of that. Well, how did it get inverted? Show that somebody's lying on the stand. Or we get to the point where someone says, yeah, I did do it. I mean, don't you think that'd be pretty powerful if you were on the jury to see you march in everybody from that police department? I know for me it would be. And someone would say, well, God, that would take forever. How would that take forever? How many people do you think work at Canton Police Department? That wouldn't take that long at all. Not if you're just asking those two questions. No more further questions. And then what's the prosecutor going to ask? No, we have nothing to ask this witness. I mean, if you want, what are you going to ask them? There's going to be, bring them all in. Bring them in. I'm just saying, let's say that I was Karen Reed. I would be telling my defense that this is what I want. I want you to bring in the whole damn Canton Police Department. Okay? Any and everybody that has a report in this case. And I want you to ask the questions. Did you have access to this video? Did you invert the video? Do you have personal knowledge of anybody that did invert the video? That's it. Move them out. Move them out. Move them out. And then that's part of your, maybe somebody says yes, but if all these people say no and we say, then we get the chief of police up there for the last person, we say, here's a document. Is there anybody that's not on that list that worked for the Canton Police Department in 2021, 2022, whatever year? The buck stops with the chief, right? So you would know everything that's going on in your police department, right? Well, we asked every single one of these people, we brought them in and we asked every single one of them if they inverted the video. And every single one of them said no. Did you invert the video? Do you have personal knowledge of who did? Would you agree then somebody's lying? Because how did this video get inverted? Have you ever inverted a video before for trial? Have you ever testified to an inverted video before at trial? This is what I'm just saying. If I was Karen Reed, I'd be like, you guys, the video didn't get inverted by itself. And now we called in every single police officer And they all said no. So we would say somebody's lying, right? We didn't invert the video. You have to make a big deal about this video because the prosecutors are the ones that brought it in, right? Why would you bring in an inverted video? And then wouldn't you finally say, damn it, Lally, you're a witness. Because wouldn't you have asked Lally where the fuck you got the video from? Where did we get this video from? Tully, where'd you get the video from? You piece of shit. So in the Delphi case, 3 months of interviews are missing. In the Karen Reed case, they're inverting videos to try to deceive the jury to think that nobody messed with the taillight while in the Sally port. Are you fucking kidding me? And this isn't your end-all be-all for your case. This, to me, is your end-all be-all for your case. But then we have jurors who 12 people go into a fucking room, and what the fuck are y'all doing in there? Y'all like getting fucked with by the police? I don't like it. Do you? Because clearly you like it. Who would see this shit and go back into a room and not consider this shit? This is ridiculous. When you have to give your verdict, it doesn't say, hey, sweet Susie, why'd you vote this way? Okay. So don't worry about, oh, well, then I'm going to have to say that I don't believe the police. No, you're not going to say shit like that. Because now you're telling me you're in fear of the police. This is ridiculous. This is crazy. How would you ever, why would I want 12 people to decide my fate the rest of my life when you're providing them stuff like this and they're looking the other way and there's no consequences for this? Yeah, there is a consequence, and it's you don't make your case, buddy. Sorry, you didn't make your case. You lied. If we're to lie, what happens? We're done. Ridiculous. Ridiculous. But you have to march all of those people in there. And then you say, here we go, guys. Somebody is lying. Why? Why? Because they think everybody say no, then what are they going to do? Well, I'm going to tell you what we're going to do. The jury, I'm going to tell you what we're going to do. We're going to vote not guilty. That's what we're going to do for their bullshit. I'm so sick and tired of seeing the same shit. Little fucking cheaters everywhere. Like those line cutters, those cheaters, it's everywhere. We have rights. And yet citizens are continuing to allow people to trample all over our rights. And I'm like, what the fuck's wrong with you people? And so and then you hear these interviews with these jurors, and I'm just like, wow, I'm sorry, I have no problem saying it. You're fucking stupid. You're dumb. And to think that I'm supposed to put, whoo. I got one question. Would you want your mom or dad convicted off of that type of evidence? Would you want your sister? Would you want your kid? And if you say yes, you're lying. You're lying. And then what are these judges like? Literally, if I'm over here saying that I didn't do something, well, clearly somebody else did. So I want to go ahead and talk about who possibly that could be, or what's going on in the world at the time of this crime happened, that there could be motives elsewhere. And for you to try to tell me that, oh, nope, you can't. If I want to confuse my jury, let me confuse my jury because they're already way confused. I'm not, these people are, and maybe that's why they're so confused, because it looks like, well, why aren't you putting on a defense? Because that's what juries think, that you have to put on a defense. Why didn't you defend yourself? Why didn't you get up there and say you didn't do it? I'm telling you, these defense attorneys are going to have to start considering, you know, when you're representing innocent people, you know, rehabilitate them on redirect if a prosecutor tries to go at them or something like that. But, you know, these juries, every single jury that I'm hearing, they want, why isn't that person screaming from the rooftops that they didn't do it if they're innocent? You're going to have to ask questions like that, though, if you put somebody on the stand, you know, hey, this jury wants to hear you say, are you aware this jury wants to hear you say that you are innocent? Yeah, I was told that by my attorneys based off of jury selection. Why are you taking the stand here today? Because I want the jury to know that I didn't do this. And if they need to hear me say that, I'll sit here and say it. You can ask me any questions you want about this. I didn't do this. I'll say it till I'm, you know, blue in the face. Well, let's talk about, you know, this, that, or you made this comment, or you said that. Well, no, I didn't, and it's not recorded. That's just what somebody wrote in a report. I mean, people want to say, oh, it's so risky to put somebody on the stand. Well, you guys, the times are changing. And we might have to consider it, because these jurors are looking, and they're not supposed to, but they're looking at you invoking one of your rights, which is to remain sound. Not, you know, I'm going with the fifth, and they're being told that you cannot use that as a negative inference. You cannot do that. Well, they are. So what are you supposed to do? They are. Do you have to have your lawyer at the end when it's a closing argument say, you guys, the rule says right here, you cannot hold it against him or her if they don't talk up there? Why would you hold it against them? They're scared to get up there. But everybody else that got up there lied. Why aren't they scared? Why aren't they scared to get up there and lie? We're catching people lying on the stand and nothing's happening. There's no consequences to lying. So fucking lie. Lie. What's going to happen to you? Nothing. Save yourself. Say whatever. There's no consequences. The last trial I've covered where there was a consequence, and it was strictly because it was when that Kayla chick, she got charged with perjury. And they only did it so they could then have her make these proffers so that they can go after Adam Montgomery. But you guys, every single juror at that Delphi case, like, why wouldn't somebody get up there and say that they didn't do it? I'd be screaming from the rooftops, I didn't do it. And some of those jurors that were on that jury for Richard Allen said, well, yeah, maybe when I wouldn't get up there because then, you know, the prosecutor's going to try to twist my words. Then there you hear your answer, right? You just said that. Like, you just said that. I wrote that down because that was your freaking answer as to why you wouldn't get up on the stand. You just said because the prosecutor could try to twist your words. And then you go in to deliberate, and you're going to hold it against the guy that he didn't get up there, but you know why he didn't get up there, because they're going to try to twist some shit, or maybe he or she, like, I think Karen Reed could get on that stand. All right? But do I think that Karen Reed needs to get up on that stand? No, she doesn't, because there's no case against Karen Reed. So why would you subject Karen Reed to that bullshit? It's absolutely unbelievable to hear the answers that I heard, and then you're going to hold it against somebody when they don't take the stand. So for me, with these cases lately, I'm just like, you know, the jury's literally, if you do not take the stand, okay, they're not following the jury, like they're not following the rules of how, they're not following the instructions. But I think defense attorneys really have to change the way they're doing their closings. They need to really wrap this up in a bow and give it to these jurors like they are in 3rd and 4th grade. They need to have reports. Anybody that you're going to have on that stand needs to have something that the jury can take back to that room that physically reminds them of who was on that stand. Okay. Fuck their notes. Fuck these jurors' notes. You're going to have just a bunch of people arguing back there. This is what my notes say, and this is what my notes say. Fuck their notes. All right? These people, they need to see timelines. Okay? They need to see that, you know, or we need to start giving them audio of what these people are saying up on the stand. But I'm telling you, these people who are jurors, they are lay people. You need to teach, you need to instruct the jury in closing. Everything that you say in the opening, you better be able to back that up. But more importantly for me, in the closing, you're going to point out, if you did jury selection, I listened to all of your guys' answers to all the questions on what you would need to see to order to convict somebody. Okay? And these are the answers that all of you gave. And that's not here, and that's not present. And I'm going to show you why it's not present. And I'm going to talk about it through a timeline that one of the investigators would have testified to at some point, so that they have that back there. It is impossible that 12 people come out of the house of Karen Reed's, where the Alberts were, and their own witnesses told you that they did not see anybody on the lawn when they left. Nobody was on that lawn. That means Karen Reed's vehicle couldn't have backed up and hit him, because he would be laying there, ladies and gentlemen. Their own witnesses got up on the stand and said they saw nobody. Where was John O'Keefe? You guys went out to the crime scene. You are not missing a body. 12 people, okay, are not missing a body on that lawn. And the only way that Karen Reed could be guilty is if she hit him, like they said, with her vehicle, and he would have been laying there since 12:30. Why, guys? Because she has to be able to be back on the Wi-Fi, right? Are we forgetting that? She has to leave the house at a certain time in order to be back on the Wi-Fi at 12:36. That means she has to leave by like 12:28. This is the tiniest of windows. And then John O'Keefe would have been laying there for all of that time. That means not only are the 12 people that walked into that house and left at that house, then you have the boyfriend of Caitlin coming to pick her up. But what about if anybody drove down the street? You don't think anybody drove down that street at all that whole night? Not a single person? Or do you think maybe some people did And they also didn't see a body. Nobody saw a body. So where was John O'Keefe? And guess what? The state doesn't know where John O'Keefe was. Based on their own testimony, based on their own witnesses, the state, have John O'Keefe unaccounted from 12:30 until 6:03. The fuck is wrong with you people? How do you listen to that case? I don't care if Proctor wants to call Karen Reed names. He's a little punk ass bitch. But that's not proving that Karen Reed didn't do it. That's not proving that. It's just proving that he's a punk and he didn't do his job. Or you got people back there saying, you guys, he was running his mouth to his friends. Any of us would have done that. Okay? We're pissed. A cop is dead. All right? I would have never thought in a million thousand years that would have ever come to light, right? But that does it change his job? Blah, blah, blah. That's what they're saying back there. So don't even let them talk like that. Say, look at this. The state doesn't know, or the Commonwealth doesn't know where John O'Keefe was from 12:30 until 6:03. All of their witnesses came in this room and said, nope, didn't see him. Didn't see him come into the house and didn't see him on the lawn. So their victim is unaccounted for from 12:30 until 6:04 a.m. What did they prove in here? That's what they proved to us. That's what you tell the jury. They proved to us that the Commonwealth has no idea where John O'Keefe was from 12:30 a.m. until 6:04 a.m. That's what they've proven in this courtroom with all of these witnesses. We've asked all of their witnesses, if you would have saw a body on the lawn, would you have seen it? And then what about the guys that drove up? Oh, wait, Nagel's brother and Richie, would you have seen it? Hell, fuck, when the time that they arrived, they would have witnessed the motherfucking crime at 12. That's when they were there at 12:30, 12:25. They would have witnessed her backing up and just drilling him. How does a jury go back into that room and find this woman? How are they hung? How is this not guilty? I mean, it's wide open. Whoa. Unbelievable. I feel like the Delphi case, those jurors wanted more from the defense and they didn't get it. And they didn't get it. You got somebody putting a timeline together in that Delphi case, it changes the whole game because they have this piece of paper that's multiple pages, okay? And you have them comparing that to Cecil's, because the one that we do as the defense is we're going to include, you know, the Betsy Blairs of the world. And when Kelsey says this and da-da-da-da, like, sad world we're living in right now. Do you go to a bench trial? I don't know. I wouldn't want 12 idiots deciding my fate. All right. I wouldn't want 12 idiots. I don't know if you want to say the word idiots. I don't know if you want to say lay people, but how do we get 12 people to even agree? We can't even get 12 people to agree to what restaurant we're going to go to when we have, you know, vacations with friends. How are you going to get 12 people to agree on something? It's almost like it's set up to fail. You get 12 people to agree on shit. You guys know what I'm talking about when you guys go to out on vacation with your, you know, you get big groups together. We can't even pick where we're going to go have dinner. And next thing you know, okay, a couple people are going here and a couple people are going there. So when people were like, I don't know if I like the whole 6 jurors in Florida thing. Shit, I'd take 6 jurors. I can't get 12 of you guys to, you know. And then why wouldn't nobody's going to get me to change my mind if they sound like an idiot. So somebody was able to get people to change their minds after 4 days that were clearly not guilty votes. They got them to change on what? What did they provide you that you changed your mind? That's all I want to know as far as the Delphi case goes. As far as this Karen Reed case goes, I mean, those witnesses have to stick to their stories because they were under oath testifying to a certain way. So it's not like the story can change. Otherwise it would be, oh, wait, you know, they can impeach the witness. But what's going to happen to them? Nothing. I feel bad. I feel bad for Karen Reed. I feel bad for Turtle Boy. I feel bad for Richard Allen because this shit ain't fair. This shit ain't just. And fuck, if you think Brian Kohlberger has a damn prayer, they better get that DNA tossed. You know, speaking of which, we should have a lot of motions being filed today and tomorrow because it's the deadline for suppression motions in that case. Someone needs to write a jury book, though, because I have no idea what they're doing in those rooms, but it's wild. I'm passionate about our rights, guys, and our rights are just getting completely fucking violated, and it's not good. It's not good. And we actually have a lot of power here. Like, we the people, we're the jury. We're the fucking jury, guys. I'm sorry, but the moment that I would see corruption or people that are held to a higher standard lying or trying to deceive me in any type of way, it's an automatic not guilty vote, because why would you need to lie? An inverted video. Have we lost our minds? I personally think that should have been grounds for the judge to be like, wait, what the fuck? This is, I'm declaring, no. You guys just played an inverted video. Did the defense ever see that? Wouldn't that be discovery? I'm giving you the video the way that I'm about to present it. Do you think that was given to the defense? The inverted video? So how is that not a discovery violation? What the fuck is going on here? How is that not prosecutorial misconduct? In an automatic, that's prosecutorial misconduct, automatic dismissal, and you can't retry her because it'd be double jeopardy. Bye. Unbelievable. Unbelievable. And then here we are, we the people, sitting there as jurors and finding it a hung jury. Are you out of your minds? And then I hear people say, we have to respect this process and jurors should be, you know, we have to keep the anonymity and blah, blah, blah. Well, maybe if we all had to say who we were, okay, we'd be acting a lot differently in a room. It's kind of like out here being keyboard warriors and shit. I get to hide behind a fake name and run my mouth. Well, you know, maybe we should have to disclose who the hell we are so that everybody knows what a dipshit you are. I mean, this is bad. This is pathetic. And you're going to sit here and tell me Karen Reed, no one's going to know about this case. And not even that they don't know about it. Everyone's going to, you can know about the case, but it's just it's been everywhere. We the people have power, and it's when we sit in the jury box there and then we all shit ourselves and, oh, it's not my life. Oh, yep. Okay, fine. Yeah. The cops wouldn't have arrested her for nothing. Unbelievable. Unbelievable. Cops are human, guys. Just like teachers, remember? We weren't seeing all these cases where teachers were getting arrested for diddling with their students, okay? And now we even got like women teachers, right? Yeah. It's because it doesn't matter your occupation. You could be a shitbag. It doesn't matter the occupation, guys. Come on. This is just pathetic. I'm sorry. I'm so heated over this shit. This is bad. And we have the power as the jury. Okay, we have the power as the jury, and it all right, guys, until next time. I know I have a live a little bit later for the Idaho 4 case. But rewind it, play it back. The hearing's on here. You guys can catch the, how this all originated with Karen Reed. This is why it's so important for platforms like Lana to grow. Thank you. I'm glad that you noticed that. Yeah. Thank you, thank you, thank you. Until next time, peace out. Thank you, mods. Auntie Bev's face. I love these names. Love it. Peace out. Remember the Idaho 4, today is the anniversary of the murders, and I can't believe it's already 2 years. So join me later for that. Bye, guys.